In the United States, we recognize multiple sources of law. Of course, at the base of all of that is the Constitution. The Constitution limits government and what government can do to affect the rights of people. And there are both state constitutions and federal constitutions. Well, a federal constitution. The second source of law under the United States system is our statutes. A statute is a law made by the legislature and then signed into law by the president. Treaties, which are agreements, again, made by the legislature and signed into law by the president, also have the force of law. Slightly less popular than these are what's called agency regulations, where agencies of the federal government, which were created by the legislature, they can make regulations and rules as to how their agency can operate, and then how the use of the things that they're responsible for. So the Bureau of Land Management, for example, can make regulations about how their agents will enforce various rules on BLM land. And then that will have the force of law to the people who are on that land. Judicial decisions, or sometimes the common law as it's called, are another major source of law in the United States. Each time a court rules on what a statute means, or in the case of the Supreme Court, what the Constitution means, that decision will stand and in the future will have the force of law. So once the court decides, consider Roe v. Wade, that a woman has a right to have an abortion, then that has the force of law, so that each time a state tries to make a law against abortion, when others challenge that law in the courts immediately look at the decision that was already made in Roe v. Wade and use that decision to declare that the law is not valid. And so judicial decisions fall under a principle that in Latin is called stare decisis, which means let the decision stand. So the common law is based upon decisions of courts, and then the recognition by other courts that those decisions that were already made have the force of law. Finally, executive orders are another form of law where the president can direct the agencies which were created by Congress and given authority by Congress to enforce or not enforce certain things. So when the President of the United States gives an order that all people seeking asylum at our borders will be detained for a certain amount of time, as long as that amount of time is within the limits set by the rules of the agency and the United States Constitution, that executive order, that rule, carries with it the force of law. It's important to remember that the United States Constitution is the supreme law of the land. And what that means is that no other law, whether created by statute or regulation or even decision or executive order, no other law can be in conflict with the Constitution. Ultimately, though, it's the Supreme Court who would decide that, who would decide if a statute or a regulation or even previous decisions or executive orders are in conflict with the Constitution. So ultimately, the Supreme Court gets to decide what the Constitution means, and therefore their decisions almost always, not almost always, they always carry with them the force of law.